Hello, everybody. Happy Wednesday. Let's get you all logged on here. Hi. How's everybody doing?
Thanks for sending the email. Thank you.
No problem. And I got that fixed, so it'll do that next time going forward for you. Yay. Thank you. No problem. Hi, everybody. Okay, I got news for you. Everybody paying attention? You guys want to write this one down. This is a good one. The reason time exists is so everything doesn't happen all at once. I had to, sorry. You want that again? The reason time exists is so everything doesn't happen all at once. Thought that was a good one, so I thought I'd share it with you. So as some of us know, LA County's moratorium is set to expire on New Year's Eve. No joke. We are seeing some kickback from some of the municipalities coming up with their own new bureaucracy and bullshit. Baldwin Park has their own rent control. I want to say it's 4% maximum. So the easiest way that I could explain this to you guys moving forward is before you raise rent, before you do anything, Google the city that the property is in and Google the city, California, and then behind it put rent control and just hit Google. Okay, if there's rent control in that city, it's going to pull up a list of all their different things that are going on. Hold on, I'm letting people in. Let me let them in here. I'm getting them in. So my trick for the County of Los Angeles is before you do anything, raise rents, terminate tenancy, anything, okay? Before you pass go and try to collect $200, I want you to type in the city, the state, and rent control behind it in Google, okay? So if you put in Baldwin Park, California rent control, guess what? The ordinance comes up of what the city's rules are. That's how I can help you to protect yourself. Okay, a lot of municipalities have come up with their own versions of rent control. Pasadena now has Measure H. And I'm glad they gave it Measure H because it's hell. It's HE double hockey sticks, no joke. Tenant has to be 1 month of market rent behind before you can do an eviction. Market rent for that city is actually for the county of LA is $2,200. So is your tenant going to use that as a forced savings account? I would, just saying. I mean, what if I had to get new tires on my car this month and I had to pay my rent $1,000 short? I'm going to do it because they can't evict me until I'm $2,200 in the rears. It's only a matter of time before these tenants learn what these rules are and what that means for them. If you're not familiar with Measure H in Pasadena, I strongly suggest you become familiar with it in a very rapid fashion. It sucks. No joke. Tenant has to be market rent behind before the landlord can do an eviction for non-payment. Market rent, $2,200. So if the tenant decides that they're gonna spend $500 on whatever this month, it acts as a savings account for them because you can't evict until they're $2,200 behind. It's gonna make it quite challenging for us because we're gonna become banks, just saying. Either that or independent landlords are going to pull out of the city and reinvest somewhere else. I mean, they're tying our hands, folks. Baldwin Park has their own measure. I'm trying to think who else has their own. There's a lot of them that came up with their own little moratorium. Some of them had them right before COVID came. I know Inglewood was really striving for rent control. And then that state AB 1482 kind of trumped things over and made people stop trying to do that. Does anybody have anything in particular they want to talk about or discuss that I need to touch on? I'm letting people in still, so bear with me if you see me touching the screen. I'm sorry. It's just what we do here, right? Who's got
Hi,
the
Patty.
biggest
I
problem?
have a question.
What you got?
My question is I have tenants in a single family home in Venice, so not part of rent control. And we are not on good terms. They want to get out of their lease that doesn't end until August of 2023. I'm willing to work with that. And I said that I will work towards finding a new tenant to replace them. But that they're responsible for, rent and they're bound to their lease until I'm able to officially do that. Because we are not on good terms, I want to make sure I step very carefully. What do I need to do, or what kind of reference can I look up in order to do that?
You're not going to look up a reference. What you're doing is you're mitigating damages. Okay.
Okay.
Work with me here. Okay. You are going to ask them to give you a notice in writing that they're vacating the premises.
Okay.
Once the unit becomes vacant, time is a ticking for you. Okay. You have 21 days to do an estimated disposition of security deposit. The reason I'm emphasizing that it's estimated is you're going to charge advanced rents to the end of term. Okay. On your
Say that one more
estimated,
time.
on your disposition of security deposit,
Yes.
when they move, you're going to charge advanced rents to the end of term. So you're charge January rent, February rent, all the way to the end of their term on their disposition of security deposit. Okay. You are going to write on there that it's estimated, because until a new person moves in, you don't know how much money they owe you.
Okay.
Okay. So that's how you handle that part of it. In the meantime, you must re-rent the property as quickly as possible, and mitigate damages. So what I mean by that is you list it for rent for a week. And if it doesn't rent in that first week, you need to lower the rent by $25 a week until it's rented.
Okay.
Okay. And you can't do an increase here. You have to start at the amount they were paying.
Oh, I do. Okay.
Yes, you cannot bring it to market value here. If you do, you have to let them out of their term and they're no longer responsible.
Oh, I see.
Okay.
Okay.
So if you want to hold your foot to the fire to the term, you've got to play by the rules. And the rules are that you try to re-rent that property as quickly as possible, and you lower the rent $25 per week trying to get it re-rented. That way the tenant can't say, the reason that they charged me so much rent is because they asked for market value, and that's not what I was paying.
Okay.
Where that can come back and bite you. So that's how you handle that, to avoid the issues that can come about.
Hey,
Okay.
Patty, this $25 every week is a lot of money. After a couple of months, it's going to be a whole big amount. Is that what it is?
It's $100 a month. And here's the reality. If you can't re-rent that for what they were paying, then how is the tenant responsible for that? See what I mean?
Yeah.
So what the law says is that you have to lower it, trying to show good faith that you're holding their foot to the fire. So if you want to hold their foot to the fire, you still have to work for them. You still have to be ethical for them. So by lowering the rent $25 a week or every 2 weeks, trying to find a good quality tenant in there, you're showing that you're going above and beyond as the landlord, trying to get it re-rented and not just holding that tenant's foot to the fire. That's why they make you do that. Got it?
Got it.
Okay. I saw another question come in. Let me see if I can go get it. Yes. Melanie, hello. Hold on. How do I prepare for trial on Monday? I've never been through an eviction. I strongly suggest that you go rewatch the class I just taught for AGLA called Preparing Yourself for Trial. Don't talk unless they talk to you, is my opinion, not my advice. Keep your answers short and precise, like yes and no, and don't embellish. Do not give anything more than what they're asking you for. Did you rent to this person? Yes. Did they pay you the rent? No. Did you serve a 3-day notice? Yes. Did they pay you in 3 days? No. They're very simple questions and answers for you. Do not give them more. Do not go into the drama. Do not tell them everything that the tenant's been doing wrong. This is not the time and place for that. It's actually not in the court's process and procedure. And when you as a landlord start running your mouth with verbal vomit, it pisses off the judge. It makes everything go the other direction. We don't want that. So wait until you're spoken to. I pinch myself with my finger. Let me show you guys. I do this while I'm in court. And I used to do this, but then I realized it took both hands. So I don't do that anymore. Now I do this. And this is reminding me, shut your mouth, Patty. Don't talk unless somebody talks to you, Patty. Keep quiet, Patty, because I want to give my opinion. I want to voice myself. This is how I remind myself, shut up. This isn't your time to talk. Because when you go in there and you do a lot of this, you do a lot of losing. Okay. Sometimes you go verbal vomit on everything that tenant's doing wrong, but in that, what you're saying, you're actually painting the picture of what you did wrong. So zip it is the best thing I can tell you when it comes to court. Zip it. Do not talk unless you are spoken to, and answer in very small yes, no, that's incorrect. This is what happened. Keep it very short, very concise, very, very, very narrow. Remember, you only have a short amount of time for your case to be heard. So you want to make sure that you're not going blah, 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 the whole time. If you have an attorney representing you, let the attorney do their job and you just answer their questions. When you get cross-examined, my opinion is this: take a deep breath before you answer them. Yes, no, or whatever you're going to say. Take a deep breath, count to 2, and then answer them. Okay? The reason I say that is so that you're calm when you're saying no, or yes, or you're answering the question that's being asked of you. Take your time, take a deep breath, count to 2, and then proceed to answer the question. Okay? There's a reason why I tell you to do that, because if it's the tenant on the other side, they get scared when you don't answer right away. And then they start with another question and another question. And before you know it, they're badgering you and the attorney's going to say something to make that stop. You're welcome. It's a trick. That's all. Okay, I'm going back so I can look because I know you guys sent me a bunch of stuff. In LA City, single family residence, the owner sent a 9.99% rent increase in July and tenant has ignored. Can owner evict after February 2023? I don't, if BAS doesn't extend. Okay, deep breath. LA City is going to end on January 31st. So February 1st, we're running it, rocking and rolling. The thing is, I don't think you could have done an increase in July in the city of LA. I would have to go look. I think they're on a complete rent freeze until, but I have to go look. So I don't think that that rent increase in July is going to hold. So we need to ask an attorney. Okay, I'm to Val now. I don't think I need to provide a shower rod, do I? Obviously, I don't need to provide a shower curtain. Wondering about the rod not permanently installed. No, you don't have to, if you're not, you don't have to provide a rod or a curtain, Val, to answer that properly. But now you have the tenant making modifications to the property without written consent of the landlord. So be careful there. Second question, please. Of course, Melanie. LARSO. A fire was started in the garage behind a duplex. The garage only used for tenant storage. Fire was set by a crazy neighbor, apparently. Our insurance allows for $10,000 for damages of a separate structure, which is obviously far too low to build a new garage. Tenant says she doesn't want it rebuilt. We hate these tenants, but agree with her idea. It's in LA RSO. I assume we have to uphold their original lease, garage and parking available, even though there is parking on the front driveway. We need to see your lease contract so that I can answer that. I got to see the written rental agreement. The biggest thing I'd be concerned with is bait and switch. And if that crazy neighbor did it, did they press criminal charges against them? And if they did, are they going to be held accountable financially for the damage that they've done? Ah, there's a question for you. I'm hoping for a no, by the way. I'm just concerned with a bait and switch issue. So that's why I want to see your written rental contract so that I can have the attorney look at it and make sure that you're not making yourself susceptible to a bait and switch issue. If a garage was included in the original rent and now you're not going to include a garage, you may want to offer a rent reduction to help facilitate that so that you don't have unnecessary exposure. Geraldo, I've seen Judge Judy. I learned to answer questions concisely. Did they teach you that on Judge Judy? I'm going to tell you, keep your answers short. Don't go into the drama of, no, they didn't pay the rent. They went out and bought a new car. That's a personal opinion that doesn't need to be shared in the courtroom. The answer there is no, they didn't pay the rent in 3 days. We don't need to know that they bought themselves a new car. That's where you make the judge mad. Don't do that, okay? Agla told me I could do an increase. Okay, let me say this, okay? And please hear me and don't get upset. At some point during the COVID pandemic, we were all told we could do something. And then 2 months later, they said, oh no, you can't do that. So we had to go back to this way. And then we were told we could do it that way. And then we were told we can't, we had to do it this way. So all I'm saying to you is there was a lot of give and take during the pandemic of what we could and couldn't do. And there still is no case law saying what we can and can't do. So I'm just warning you, you may have to remove that increase and go after them in a different manner. And that's all I'm saying is I get that somebody told you you may have been able to do that. And at that time, you may have been able to. But then the law changed and then you couldn't and you would have had to retract it. So all I'm saying is just make sure your increase is valid before moving forward. That's all. I want to make sure. I don't want to set you guys up for failure. Okay, so that's all I'm saying is let's double check before we go for the jugular. Okay, I hope that makes sense. People are coming in. Let's get them in here. Hello, 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 hello. Thank you for joining us. We're answering questions. So if you guys need a question answered, you can type it in the chat or feel free to unmute yourself. Back to the question about tenants that want to terminate the lease early. If I want to increase the rent, then I'd have to formally end their lease on a set date and then proceed as I would for any other turnover. Yes, you have to take them off the hook. If you want to do a rent increase and re-rent for a higher amount, you have to allow them to terminate their lease. Okay, and not hold them to term. What is the status for a rent increase in Larso? Any news? No, not yet, David. Anything under LARSO, I wouldn't do an increase and then until February 2nd, and I'd even talk to me then before you do it, because they got some weird things going on there, believe it or not. Okay, Bonnie, if we mutually agree on a set date, at what point can I start showing the house to prospective tenants? The key there is mutually agree. So it's whatever you two mutually agree on. Sorry, you guys, I'm in a chair where my feet don't touch the floor. So I keep moving because my feet don't touch the floor. The problems of being short, sorry. I used to wear heels all the time and then I didn't worry about my feet not touching the floor because my heels always did. But I'm too old for that yet. I'm getting too old for that. Besides, I don't need to be taller. I want to blend in and hide in a crowd, not stand out. Okay, anybody have questions for me? Okay, I'm going to share this again because I thought it was a good one, especially for us property managers. I opened with this. So the reason that time exists is so everything doesn't happen all at once. I'm okay with that statement. I got a new shirt. I got to show you guys. I think you'd like it. It's my new flannel. I know Val will love it. It's cold in my office today for some reason, so I threw my flannel on. You ready? It says, oh, can you guys see it? It says, not my circus, not my monkeys. Can you, oh, you can't see it. Oh, it says, not my circus, not my monkeys. I thought it was really cute. Okay, I got more stuff coming in the chat. Patty, if Larso, can you increase parking rate if paid separately in January? I don't know yet. I want to say there's no increased expenses to the tenant. And I know you didn't want to hear that, but that's how I see it, is no increased living expenses to the tenant during the pandemic period. But that's how I see it. I'm not an attorney. I just try to avoid litigation at all expenses. Sorry, Geralda. I love you guys. I love you guys. I love you guys. My arms will not be swinging when I get to court. You have to take my class to understand that. But let me tell you guys something. An attorney once told me a long time ago that she always dreaded when we came walking into the courtroom, if our arms were swinging when we came into the courtroom, she said, shit, this case is gonna lose. That's what she always said. And she was pretty smart. She knew. If you're walking into the courtroom and your attitude is, I already gave everything to my attorney, they got this, I don't have to do anything but answer their questions, you're losing. You just put all of your eggs in someone else's basket and are depending on them. I get it. I know you hired them. But don't you check on a roofer after he does a job? Or a plumber? There is no excuse that you should not have all of your documents when you appear in court. I always take my tenant file, my move-in inspection. I take the whole tenant file. So it's got all of my move-in documents, any correspondence that's happened throughout the tenancy is in there, okay? The weird stuff. Here's what I could tell you, and I learned this a long time ago, so pay attention. And I love that your arms will not be swaying. Mwah! Thank you. Mwah! Because that means you pay attention, and I love that. You want to take with you any repair receipts, but here's my thing. What's your answer say? Not the one you filed, because you didn't file an answer. Your tenant filed an answer. What's it say on that answer? Because when they get into court, technically, all that they can argue is what they put on the answer. So if they're arguing habitability issues, personally, I would try to go gain access. If they didn't give me access, then I would argue with the judge that how could I provide habitable premises when they won't allow me entry? See how that worked? And this comes from my corporate America career, okay? So that's how we combat that. But whatever's on their answer is what can be argued. So if all they're arguing on their answer is they can't pay the rent because their dog died and they didn't have the money, that's not gonna work. A judge isn't gonna tell them they get to stay there because their dog died and they don't have the money to pay the rent. Whatever's on their answer is what they can argue in court. So that's how you want to build yourself to prepare for what they're going to throw at you. It's kind of like they're giving you a roadmap of what they're gonna say. Did that just click? And let me say this, you know how a lot of times the tenants write out this BS drama letter? Take the drama out of it and read the letter without the drama. Is it saying you're doing something wrong? And if it is, that's where they're gonna argue. Does that make sense? If you take the emotion out, it's easier for us to tolerate, because our first reaction is, oh no, they did it. They did not just say that on court documents and tell the judge that I did that, because I would never do that. You're reading it wrong. Take your emotions out of it and read it again. And then take the tenant's emotions out of it and read it again. The idea for you is not to get caught up in the drama. Remember, we just had a conversation of how you conduct yourself in court. We don't say, oh no, the tenant didn't pay the rent. They went and bought themselves a new damn car. We don't say that. No, they didn't pay the rent, Your Honor. The fact that they bought a car is not relevant in the courtroom. It is for us because it pissed us off. But we don't want to be poking people in the eye. You know why? Because we sure the hell don't want them poking our eyes. Got it? Whatever's on their answer is what they can argue in court. So it's a great way to start building your defense of what you're going to talk about based on what their accusations are. Remove your emotions, because come on, let's face it, we all have them. These are our investments. We're invested, okay? They are attacking us when they don't pay us. I get it. But they're giving you a roadmap when they file an answer of everything that they're going to talk to the judge about. So that should be your list of everything that you have to defend their claims. Does that make sense? I hope that puts you down the right rabbit hole when you're preparing yourself for trial, okay? I fixed this stuff in his answer. I have before and after pictures. Did you fix this stuff or did you hire someone? Because I'm going to tell you, if you hired someone, bring me paid invoices with you. And if you have before and after pictures, I'm going to tell you this. Run down to CVS Pharmacy or whatever pharmacy you have, Walgreens. You can even do this online through Walgreens photo app. No joke. You email them the pictures you want printed and they have them printed for you up at the front. You need 3 copies of each photo. So you figure out the best way to have that for court. And I don't mean 3 copies on one piece of paper, okay? So you get your copies of all your photographs you're going to use before and after and make your master sheet where you write before and the date you took the photo and the after and the date you took the photo, okay? And you put as many of those as you can on one sheet of paper and hit copy. You need 3 copies of that packet that you're making. 1 for you, 1 for the judge, 1 for the tenant. Got it? 3 copies of all documents. You keep the original, so you need 2 copies. I'm sorry. You keep the originals. If your attorney wants to see it, let him know that's the original document. That way he doesn't keep it in his file, okay? Sometimes attorneys will take your document. Sometimes they take the document and now it becomes court evidence. So I always take a copy of my tenant file for myself in case I'm giving away the only document I have. I don't ever want to do that. So I always take and make 3 packets. You keep the original, bring it with you, but 3 packets. That way, if you pull out a document and hand it to them and you never get it back, it's okay. You still have your originals. Okay. I know this is talking about a lot of paper. We're talking about spending a lot of money on printing, but that's how you prepare yourself for court. Okay. I know it's expensive, but come on, you're defending yourself. Defend. It's not cheap. Okay, so make those 3 copies. 1 for you to utilize, 1 for the judge to look at, and 1 for the tenant, and they should all be in the same order. So you can say, Your Honor, we're discussing the before and after pictures on page 6. he can turn to page 6 and so can the tenant. And you guys are all looking at the same documents. You're all on the same page and you're all reading the same book. 3 sets of your documents, okay? I'm going backwards. One thing I am concerned about is I crapped the attorney's fees clause. Oh, capped, I said crapped. Sorry. I capped my attorney's fees clause to 0, but my UD is asking for attorney's fees. I hope that doesn't compromise my case. Let me ask you a couple of questions. Did you do a 30-day notice of change of terms of tenancy to cap your attorney's fees, or is it in your original contract? Okay. So if the tenant doesn't argue, shh, and I'll leave my statement at that. Ding. I hope that worked. I hope that clicked. If you lose and you have to pay attorney's fees, yeah, bingo, right on the nose. So when I do this to you guys, that's what I'm saying is you're right on the nose, okay? Right on the nose. You're right, your thinking's right. In the event that you lose, I'd pull that out immediately so that you don't have to pay attorney's fees. Just saying. Hi, Patty. Any new laws pertaining to ESA or service animals? Hi, April. Everybody say hi to April, our money gal. Remember during COVID, she would tell us all about the money and where, who had funds and how much and how to apply and how to, yep, April, our money girl is in the house. New laws regarding, everybody's gonna say hi to you, April. New laws regarding to service animals. January 1st, 2022, we got a new law in regards to service animals. I want you to be careful with this law. Nobody's talking about it, and there's a reason why. Okay. With that being said, pay attention. It is now required as of January 1st of 2022, so this year, that tenants, with an emotional support animal, service animal, therapy animal, any of those, have to be seeing the doctor that writes the note for 30 days before the note is written. What does that do? It's going to stop all those Amazon bullshit emotional support letters. It's going to stop all that garbage, okay? There's civil fines and penalties for a tenant that lies, and civil fines and penalties for a medical provider that lies. So there's more consequences for being dishonest going forward. The reason nobody's talking about the new ESA laws is it's too easy for it to be retaliatory because of COVID. You watch with the moratorium in the county lifting at the end of this month, January, everybody's going to be talking about the ESA animal changes that happened last year. We're just trying not to enforce them right now because of COVID. It is way too easy for a tenant to say it's retaliation because of COVID. So don't do anything in LA County until the moratorium ends regarding the new laws for ESA animals. Okay. Just today, one tenant says she's been accepted for housing assistance in Kern County. I thought this program was over, but I'll find out later today if this is true. There are some programs where funding is still available. Please remember it was issued by county, the money. So I can tell you that Santa Barbara County is out of money. LA County is out of money. Riverside County is out of money. The funding from the federal government is gone. No joke. But there are Live to Rise in Riverside County that has funding available. And there's something else. I'm trying to remember the name of it. But there's a few There are a few out there that have funding available. But here becomes my question. You're not required to participate in the program. Want me to say it again? You're no longer required to participate in the program. So if you want to listen to some tenant program tell you how they're going to pay you and how you've been approved, and there's a check in the mail, then you go right ahead and listen to them. But I want the money in my hand. Okay? A lot of these programs don't have funding available, and they're getting tricky on how they pay. So if the tenant owes for this, this, and this, they're not paying during that COVID protected period. They're paying for right now going forward. Why? So you can't evict. You think they're smart? They figured it out. Okay, I saw more stuff come in. Let me see. Hi, Patty. You're welcome, April. Anytime, baby. Hi, Patty. Can we send a 30-day notice to change terms of tenancy in the city of Montebello, LA County, starting January of next year? It's for all tenants to remove cameras that have received permission from the owner. Sorry, I know I sound like a broken record about this issue. Yep, it would be a 30-day notice to change the terms of tenancy to remove any electronic devices from the exterior of the home that were installed to the real property. There you go. And Montebello, I wouldn't do anything about it until January. You're spot on with your timing. Hi, Lee, how are you? How do you know whether or not a tenant has been seeing doctor prior to 30 days? Read the note. A lot of them say things like, this patient just recently became under my care. This patient has been under my care for several months. This patient has been under my care for several years. You can also call and ask, how long has this patient been seeing you? How long have you been seeing this patient? A lot of them now know that there are civil penalties, and they won't write the note until they've been seeing them for 30 days. So what they do is they send a note saying, hi, this is my patient. We're in the midst of some review and some testings. You'll be hearing from us in the future. They're waiting for 30 days to pass so that they can write the note. All this is going to do is stop those dishonest people that bought those things on Amazon, and they don't want to go to the doctor. They don't want to see anybody. It wasn't real. That's what it's going to stop. Okay. It's not going to stop all of it, just a portion of it. And let me say this. This law is passing in January, and it is passing. So pay attention. Anything built in 2023 going forward is allowed to have pets in the state of California. New construction is allowed to have pets going forward in the state of California. So you can't say no pets in 2020, 2030. If it was built in 2023, you have to allow them. And here's the reality of that. They're going to bring them in anyway. Allow them, get the higher deposit. They're going to do it anyway. I hope that makes sense. I know pets do damage. They cause problems. You know what? If they cause problems, you get to evict the people. If they do damage, you get to charge them for the damages they did. Don't overthink this, okay? Don't overthink it. I get that we may have allergies. I get that it may not be cleanly for someone else. Then clean the unit and charge the tenant that vacated. I know you don't like my answers, but I'm trying to make you understand. Don't overthink the complexity and all the moving pieces. My daddy always said, keep it simple. Keep it simple in a way that we can understand it. Just allow it. Ask for a higher security deposit because they have a pet. They're going to bring them in anyway. It's kind of like telling people, don't breathe out bad carbon dioxide. Only breathe in good, clean oxygen. Just allow it. It's so much easier. Get that higher deposit. And I explained to someone yesterday, I'm going to explain to all of you guys right now. If you're doing a lease contract and you're moving someone in, whether it's on a month to month, on a 1-year term, on a 6-month term, whatever it is that you're doing, this is your chance to make sure all your ducks are in a row. This is your chance to make sure you're protecting your asset to the best of your ability. This is where you line up your documents, prepare your documents, ask your advisor, ask your attorney, ask somebody, hey, do I have all my documents in a row? This is what I was doing for a move-in packet. Do you see anything I'm missing? Second set of eyes, okay? This is your chance. You don't want to mess this up. In a lot of cities, Larso is one of them, anything governed by RSO or DCBA, however you want to call it, you can't change the terms of the tenancy unless it's mandated by law. Is your annual rent increase your attorney's fees clause, or you must both sign and agree to it. Good luck trying to get a tenant to sign and agree to something that doesn't benefit them. But you will when they want to move in. So at move-in is your chance to give them all your disclosures and all of your rules. Okay? This is the time to go through that checklist and make sure that you have everything that's required by law. Do you have the flood zone? Do you have the new mold disclosure that offers photographs? That's a requirement. Lead-based paint, asbestos, clothesline drying racks. And if I could give you the one that everybody wishes they did, but they didn't, and they should have, is going to be your water conservation addendum. Patty, why do I need that? Because 2 years from now, or maybe 6 months, you never know, it is California, we may have a drought again. And they may go back to odd and even numbered addresses being able to water. If you don't disclose that that might happen and that we need to conserve water in our state, and the water company comes out and finds your tenant washing their car on the wrong day, who gets that fine? The tenant? The landlord. Okay, so wait a minute, Patty, who has to pay the fine? Well, did you disclose to the tenant when they moved in that this may or may not happen to them? And if it does, they would be responsible for those expenses. Water conservation, very important addendum to have, especially here in California. Just saying. Not a requirement, but it is for me. Do you want to know how I know? I learned that one the hard way. I was in corporate America at the time. We got an announcement there was a drought, and we went to odd and even days watering, and all of a sudden all these tenants were violating the laws and the owners were getting fined. Who's responsible to pay that? Did I disclose it? A lot of times I tell you guys this stuff because I learned the hard way. Oops. I don't want you to make the same mistakes. Water conservation is something, Agla's working on it right now, Arlene. I talked to Dan about it yesterday, as a matter of fact. Hey, you guys told me it wasn't there. I made sure it's gonna be there. It should be there by the first of the year. I talked to Dan again about it yesterday. He asked me something. So it's something that we work on. And thank you guys for bringing to our attention that we need to have documents there. There's another one that I offer that isn't anywhere, okay? And this is what I could explain to you guys. Your lease contract is written in terms that you don't understand, and you guys don't like the way that it's written because it's like this big blanket they just kind of threw at what you're concerned about. The reason that they threw that big blanket in there and it kind of covers everything, so it covers everything. And when you then try to come up with your own house rules and you're changing it so it's more defined, then yours is in control and the lease contract isn't. And if you didn't put it in yours, you're not protected. We're not attorneys. I'm not an attorney. You're not an attorney. So stop trying to figure this out. Leave it for the attorneys that wrote the legal jargon and know that you're protected. Don't try to figure it out on your own. A lot of us try to write in detail this big long laundry list of house rules. And the reality is what we're asking them to do is covered already in our contract under those blanket verbiage, you know, like tenant can commit no waste and commit no crime on the premises. Oh, but you can't do this and you can't do that. They can commit no waste or no crime on the premises. Oh, but it doesn't say, yes, it does. It's a blanket statement. Okay. Don't try to figure out the little independent pieces and moving parts. You'll drive yourself batty. How do I know whether or not a tenant has been seeing a doctor for 30 days prior to the doctor writing the ESA letter? Lee, a lot of times, and I know you've seen the ones that come off of Amazon, it's going to eliminate those. The doctor must be in the state of California. A lot of those Amazon ones, the doctor's out of the state, so it's going to eliminate that. Okay. So we're going to see a lot of it that way. And then you can usually tell by the way that it's written, this patient has been in my psychiatric care for the past 4 years. They're disclosing to you right there. And that's why they're doing it. They're letting you know. So that's what I'm saying. If you get one that discloses how long they've been under care, you're done here. Don't challenge it. And you can always call the doctor's office and ask them how long they've been a patient. They might not tell you. That would fall under HIPAA law, but it's worth a shot. Okay. Hi, Tony. In the unincorporated area of LA County, in East LA specifically, which I know is in unincorporated LA. Under RSO, I want to terminate my parking agreement with a problem tenant. My parking agreement is distinct and a separate form from the rental agreement. There are no fees for parking, and as far as I know, they are not disabled. They are young and in their 30s. When can I give a 30-day notice to terminate the parking agreement? January 1st or in February of 2023? Hang on. East LA, so that's under the county. East LA is under the county moratorium, not under the city moratorium. East Los Angeles is in the unincorporated part of LA County. It is not city of LA. Because it is on my list of unincorporated. I hope you guys can't see me. I'm sitting here picturing the document. I can see it. It's on the second page of the 144 cities, and it says East Los Angeles, which tells me that's in unincorporated LA County, not city of LA. And you most likely are going to be able to do that on January 1st. But I'm going to tell you this, Tony, send me a copy of the contract so I can have the senior paralegal or one of the attorneys look at it just to make sure that you can do that and there's going to be no issues. Okay. Email it to me, widget@widgetsway.com. Okay. And I'll have one of them look at it for us. Bed bug addendum. It's required by law. Bed bug addendum, lead-based paint, asbestos, mold disclosure, AB 1482 disclosure, or statewide rent control, Tenant Protection Act, 1946.6, depending on how you want to do it. I have a bunch of addenda I use for my own personal rental properties, and I'll explain this in just a second. I don't think that AGLA has that addendum. Which addendum? Which addendum? Are you talking about the water conservation? Because they're writing it. Is it illegal? I'm sorry. Is it legal to offer a vacant unit under AB 1482 for lease for 11 months? Yes. There's nothing out there that says that you have to have a 1-year contract, Lee. So what we're seeing isn't an 11-month contract. Honestly, they're starting them on a month-to-month and leaving them on a month-to-month. And the reason that they're doing the month-to-month and staying on a month-to-month is for the exact reason you're saying, Lee. And let me say it this way so this helps. Okay, because I know somebody else is going, what are Lee and Patty talking about? Years ago, we had a problem with tenants moving into a property and then staying 1 or 2 months and turning around and moving out. It was when there was a lot of buying going on. And when I say years ago, it was over 15 years ago. I asked somebody and they told me, Patty, that was 20 years ago or more. Okay. With that being said, we don't have that problem right now. We don't have tenants moving in, staying 1 or 2 months and moving out. They're moving in and staying there for the most part. Okay, we don't have those issues. So for the most part right now, people are moving people in on a month-to-month contract, 30 days at a time. That way, if you don't like them, you can tell them to GTFO with a 30-day notice. You only owe those reloads if they've been there 1 year or longer. And that's what Lee's talking about. She's trying to avoid those reloads. So that's the how and the why that we're speaking of.
Patty, I have a question.
Sure.
Okay, I had a situation of a Section 8 tenant. She passed away on the 6th of the month. I called the caseworker. She said, no, the day she dies, everything stops. And then I sent a letter to Section 8. I said, look, this patient died on the 6th, but the family vacated at the end of the month. So you decide what to do. But they paid me for all the time the furnitures were there. So I really still don't know what holds true. One of them said this way, the other one said the other way. So do you have any idea what's going on here?
Due respect, let me answer your question. When your tenant dies, Section 8 payments die with her. They're exactly correct. However, she died on the 6th of the month. So you would have been paid December's rent. You will not be paid January.
Yeah, but they have to kind of prorate everything, no?
No, they don't. You're welcome.
Okay, thank you.
I'm trying to explain to you, they pay you for the whole month. When you do an eviction on Section 8 and the tenant, you can't take the tenant's portion, you can still accept Section 8's portion. And they may pay you their portion all the way through the eviction. You get to keep that. Okay? So Section 8, if you have someone that dies and they die on the 7th, and they've already cut your check for December's rent because they paid you, she lived there on the 1st, the 2nd, the 3rd, the 4th, the 5th, the 6th, they're going to pay you for the whole month. In an eviction matter, they will pay you all the way until they're evicted. So in that eviction month, sometimes the lockout's on the 4th, but they pay you for the whole month. That's okay. You get to keep that. Okay. But the following month is when it'll be cut off. So, and if they accidentally pay you over and they don't stop, hold that money in that account. Because when they figure out they made the mistake, they'll come in and swoop it right back.
I got it. Thank you, Patty.
Okay. And like, don't play with them. You leave, if they send you something they shouldn't have, leave it sit in your bank account because they will come back and they will swoop it right out of there. And at the most inconvenient time possible. All right, you guys, we're coming up on the hour. I'm still going through questions, but just want to make sure I address everybody. Okay, thank you, Tony, Arlene. Barbecue. A barbecue addendum? I didn't say any, the water addendum. Yes, AGLA does not have the water addendum. I got you. It took me a while. Yes, Hollywood does require 12 months. You're spot on. Some municipalities require a 1-year contract at a time. And then if the tenant won't sign a new 1-year contract, you can evict. I believe that's in West Hollywood. And I remember that because of Wicked Witch of the West. Sorry. I think West Hollywood requires that. There's like 3 cities that require it. One of them is West Hollywood. I want to say it might be Santa Monica. I'm pretty sure it's Santa Monica is the other one it might be. I have to go look them up, you guys. I keep a lot right here, but not everything. I know. And the reason Lee is asking, just so everybody knows, Lee's in San Diego County is why I'm telling her she can do a month to month. And I know she can do a month to month because she's not anywhere near LA. She's on the opposite side. She's in San Diego County. Hi, for new lease. Okay, hang on, Tony. For new lease agreements, what verbiage should I include about visitor stays? I have an applicant that says his wife lives in Kern County and has her own place and will not be moving in with him in LA. But every month for 1 week wants to stay over with him and her service dog. How long can the visitor stay? And what about the animal? Can she bring him even though she doesn't live there? Thank you, Tony. Tony. We're not frozen, you guys. Patty's in the zone. Tony, my candle lady. She my girl. This creates quite the conundrum. You're asking me specific questions about her dog and her service animal. And the key frame in this whole little convoluted picture is that they're married. And marital status in the state of California is a protected class. So if he's qualified to live there and he moves in and he lives there all he wants, are you going to tell him his wife can't visit? Are you going to tell him his wife can't live there? Chances are she's moving in too, sweetheart. And if he is telling the truth and she's only coming to visit for 1 week every month, her and her service animal, I'd be shocked and amazed. But you know, I mean, maybe that's why I'm single. Maybe I'd be better off just trying to spend a week with someone instead of a whole month. Just, I'm being funny. Sorry. Maybe that's all they can tolerate. I'm trying to be funny. What I'm trying to say to you is marital status is a protected class in California. And we as property managers make a lot of mistakes when it comes to dealing with marital status. Example, single woman moves in with 3 kids. She's approved. We love her. She's great. She meets all of our criteria. We move her in. The day after she moves in, there's a gentleman there. And we ask him, hi, who are you and how are you related? You know, what's going on? I'm her husband. Oh, she's not required to disclose if she's married or not because we can't discriminate against that. She didn't let us know that she was married. And I can say that you're an unauthorized occupant, but you're not because you guys are married. So now all I can do is ask to add you to the lease contract as an authorized occupant and see your ID so I know who you are and add you to the contract as an authorized occupant. Because you're married, I can't discriminate in any way, shape, or form.
But you can increase the rent, right, for additional person.
Possibly, but I wouldn't. They're a protected class. I'd ask my attorney before I tried to do anything like that. Do you understand what I'm saying? You're poking in a place where it's marital status is a protected class. It's just like when children are throwing rocks in the pool. Okay. You can't write the tenant a letter saying, hey, your kids are throwing rocks in the pool. They're a protected class. They're residents from within your unit were seen throwing rocks in the pool today. Residents from within your unit. We don't call them children. They're residents. Okay, so we just want to be careful with how we handle that, Tony, and I hope you're hearing me. Is she may be going to move in there and be there permanently. And if they are, and they do that a lot, especially if the other person isn't qualified, okay? She might just be living there, you never know. If I could give you one piece of advice, it would be this. Go look them up on the court's website for vexatious litigants and make sure that they're not marked as a vexatious litigant. Val, sounds like a lie when we're considering renting to a little old lady until she said her grandson visited often. Red flag. So does it the same thing to apply to children and over who move in after the resident lived on site for over a year? Children are a protected class in the state of California. Where you're gonna get them as your max occupancy with them having too many children. It's that occupancy limits that you set. And that's how you'd handle that. But it's just a very touchy subject. If they're kids, if they're married, that's a protected class. You got to be cautious about it. Tony, what clause about visitors do you have in your rental agreement or should I use in mine? Thank you. Visitors cannot stay for more than 3 consecutive days in a 12-month period without written consent of the landlord. I'm not saying that they can't have a guest for longer than 3 days in a 12-month period. I'm saying they need to have my written consent to do so. And then if somebody said, hey, I just had a baby, my mom's going to come and stay with me for a month to help me out, then I would take them a document and ask them to sign it saying that she's a guest in the home and has no rights as a tenant. That she is only a guest. It's called a long-term guest agreement. Thank you, Andrea. A daughter moved in with her father, but did not notify the landlord. We provided an application to the daughter, but we are now hearing crickets. Until they actually identify themselves as related. Unauthorized occupants, 3-day curable breach of covenant all day long. Until they come to you and say, here's my ID, we're related. Sorry, how do you know they're? You get where I'm coming from? Get her, April. Because we don't know how old this daughter is, you guys. So this could be a 30-year-old daughter with a 60-year-old father. You understand? And if it's a 60-year-old father and a 30-year-old daughter, maybe that's not his daughter, April. I'm just saying. And good for him. Sorry, I had to. I know my men folk are laughing out there right about now. At least I made you giggle. A daughter moved in with her father. Okay. Yep. Serve them a 3-day curable for unauthorized occupants. Because at the end of the day, yep, you can do it for unauthorized occupants because they haven't, you say that it's your daughter, but how do I know? You know, maybe you're into that. I don't know. Maybe you're a gold digger. I don't know. Yes, don't use children in a letter. We've been sued for discrimination. Gabby's not joking. Don't use the word children. Don't use child. Don't use kids. Don't use little people. At the end of the day, it's a resident from within their unit. An occupant from within your unit. A guest from within your unit. A jerk from within your unit. No, don't put that one. Just say it. All right. Do you guys have anything else for me? I don't want to bore you with my shenanigans.
Patty, can't you say these people have to be at least supervised by their parents? I mean, at least you have the right to say such a thing or no? Wow.
Okay, so let me show you how that gets you in trouble real quick, okay? Underage minors must be accompanied by an adult at all times when in the common area. Okay, would you agree with that statement that you could put that in a lease? No, you can't, and I'll tell you why. That means that Gabby knows, shh, Gabby, be quiet. Shh. I'm just kidding. I'm grateful for all of this because it kind of seals the deal of, yeah, Patty knows what she's talking about. We got sued for that, and that's exactly what happened. Okay, so Gabby's telling you she's been sued for this. Gabby, do me a favor. Tell me how much your tenant won. If you want to share that, because that's really what we want to know.
Yes.
Speak, how much is it going to cost us?
They got 100,000.
$100,000.
Our insurance paid 80,000. We paid 20. And it was over a letter that they were running up and down the stairs. Kids got hurt. And we said children need to be supervised.
That's it.
And that cost us a lot.
$100,000. Look at it this way. What if my child, who is 17 years old and has graduated from high school, is going to and from her job, but you want me to walk down there and walk her through the common area as she's going from her car to my house? That's discrimination, hands down.
The lawsuit was for 650,000, but we went to
You settled,
discovery litigation.
you just said,
It was awful. Yeah, but we settled for 100.
how long did the tenants live there after they received the payment?
They're still there.
$100,000 and they're still living in an apartment.
We couldn't get them out.
Oh, they don't want you to get them out. I'm just saying, they didn't even take that money and go buy a house with it.
We offered more for them to move and they didn't want it. And there was nothing we could do.
Okay, so are you guys paying attention? This is the real stuff that happens out there. And that's why I talk so much about it, is I don't want you to be in the same boat. And thank you, Gabby, for sharing. We learn this stuff the hard way sometimes, and it's expensive. You heard her, 650,000, and they settled for 100K. Ouch, ouch. And thank God the insurance company stayed involved. No joke, but you cannot say anything about them supervising children except for one place and one place only. And it's only because it's a state law in California. And I'll read it to you because it's embedded right here in my brain. And it says, children under the age of 14 must be accompanied by an adult when using the swimming pool. That is the only time you can use the word child. And it has to be posted on your swimming pool. It can be in your rules. It can be in your lease contract. Children under the age of 14 must be accompanied by an adult when using the swimming pool. It's a state law, and the only time you can use the word children, child, playing, anything along those lines. And you can't ask them to be supervised. You can't. I know some adults that need to be supervised, just saying. And shit, if you leave me alone long enough, I can use some supervision, especially if I'm in the mall or something. I'm just saying. So keep that in mind, you guys. These lawsuits are the lesson is be careful what you say. You cannot make it so children must be supervised. Kids have to be supervised. They are a protected class, just like married folks. Okay, I'm sure that, and thank you for sharing. I appreciate that. And I love you for sharing, Gabby. No, that's how we were sued. You can't tell people that they have to watch their kids. You just can't. You can tell them that your occupants from within your unit were seen throwing rocks in the pool today and they have to stop that. And if we have to send someone in there to go get them out, we're going to charge your account. LARSO, are we allowed to put locks on the tenant's hose pipes? I know what you're talking about. Is it a multifamily community, Melanie? What she's talking about, you guys, is a special water key on a hose bin. and they use them a lot in multifamily dwellings. It's a special hexagon, weird looking thing, and there's no spigot for you to turn. You have to have that key, you put that key in, and then you turn that key and the water goes on. So yes, you can put them on in Larsoa, especially if we're in a drought. But I need to know, you have to put them on all of them or none of them? You know, we got to talk about it, Melanie. But yeah, you can. What's the lesson? Don't tell tenants that they need to supervise their children. Absolutely. Do not tell them they do not need to supervise their children. You're going to keep you treat their, treat all of your residents the same. Treat all of the occupants the same. If you had an adult occupant, I'm just saying, and let me think of something that I've had to deal with it. Oh, I can't say that one. That one's bad. Okay. If you have adult occupants that are parking 2 cars in their parking garage in their space, and they're only supposed to have 1, but they're shoving 2 smart cars in there, and you can't allow that, are you going to say adults from within your unit? You don't know who parked there. You don't know whose bright idea that was, whether it was the husband or the wife. So are you going to say your husband can't park that way, or your 16-year-old new driver can't park? No, you're going to say residents from within your unit have parked incorrectly in the parking structure. You're not going to write a letter to the wife telling them their husband's an idiot and can't drive. Residents from within your unit are parking improperly in their scheduled parking space or their assigned parking space, and we can't have that. Refer to them as occupants or residents, not their husband, not their kid. Got it? Correct. You cannot tell tenants that they need to supervise their children at all. Did Gabby write it in an email? She said she put it in a letter. Gabby, are you still on? I don't know if she's still on.
I'm still here. Okay.
How did you guys do it? Did you send a notice?
So we basically sent it was a written notice from our office to please, because we've had issues kids falling and running up and down the stairs and getting hurt. We basically sent the tenant a letter stating that there was an issue with kids getting hurt. So we asked them to please supervise their children to avoid any injuries. And that was pretty much it.
And what got you the hardest probably was, well, it was probably supervised children, because I know that's a protected
Yes,
class.
it was basically using the word children, supervised.
Yep. They're
So,
protected class.
and they went to this really difficult attorney. That was their niche, is just to sue owners about discrimination.
I know those ladies. I call them the dragon ladies.
Yes, and they want a crazy amount. Thankfully, like you said, our insurance covered part of it, because in their answer they said that they were getting sick because of the whole issue. So because it was like a form of bodily injury,
Stress.
Stress, exactly. Our insurance was able to stay on the case.
Well, thank God that they put that in there and looked at it that way, and your insurance helped pick up the bulk of the BS, because, and I agree, it's bullshit. But yeah, children are a protected class, no joke. I try to tell people all the time. And you can send letters, just say residents from within your unit were heard fighting and arguing yesterday, and it's affecting the right to quiet enjoyment for neighboring residents. And we can't have that in this community. See how I worded it? And it's okay. But I'll tell you, always have somebody else look at your letter. Always have somebody else look at what you're doing. That's usually what helps, is when you have somebody go, wait a minute, you're addressing this incorrectly. It should say residents from within your unit. Unfortunately, we have to use caution when walking downstairs, and please use the safety handrail when walking down the stairs so no residents from within your unit injure themselves. Sometimes it's better. You got the right idea, Geraldo. Don't write the letter. Call Patty if you want to write a letter. I get a lot of those where people send me this long letter and I send it back, and my version reads, with the summer months approaching, please consider when you're using your outdoor cooking not to have them too close to the building's exterior so that we don't have any accidents. I didn't mention children. I didn't mention spring break. I didn't mention summer vacation. I didn't mention, okay? Very careful how you word things, especially if you're putting them in writing. Okay, anybody have any questions? It's a duplex. The tenant is a waiter. Hold on, Melanie. Let me get back to you. It's a duplex. The tenant waiter, hold on, I gotta go back, Gabby. Hold on, just let me go back. What are you, it's a duplex. Melanie's asking me. Tenant waiter bill is they wash their ice cream trucks, but just our luck, it was their property that had the fire in the garage. Honestly, I wish the higher. Okay. That's why people usually use locking hose bibs, is so residents aren't washing their cars. So one of the house rules would be no car washing on the premises. And then you could lock your hose bibs. Just saying. And I always try to do no personal agriculture. You're not allowed to grow anything in any one of my properties. You can't even grow an avocado seed in the windowsill. No joke. I have a non-agriculture disclosure for my rental properties. I don't allow them to grow anything. There's a reason marijuana, okay? You guys ever walk through an apartment community and there's a jungle in front of one of those units because there's somebody that's just got a green thumb and they want green everywhere and it literally is a jungle to get to their front door? I don't want that going on in my community, and I'll tell you why. Who pays for the water? If you want to build a greenhouse, not at my expense. I hope that just went bing with all of you guys. That's how I combat those things, is I just tell them I can't do it. And I can't say you can't have potted plants in the front of your property because they'll just do it on their kitchen table and it's still at my expense. So what I do, sorry, you guys, somebody's trying to call me. I'll yell at her later. So what I do is I just make it so that they can't grow anything on the property, because then I'm not paying for their green thumb. For whatever it is they want to grow inside, outside, I don't care. I just don't want to pay for it. Non-agriculture disclosure. Sorry, you guys, somebody's texting me now. She's telling me, I tried to call you, but it went straight to voicemail. Yes, it did, because I'm in the middle of a webinar with my peeps. Can you add a no personal agriculture in the addendum for current tenants in the unincorporated of LA County under RSO? Thank you, Tony. And thank you guys for all understanding why I do that and what it stops. People go, oh, that's so rude. If you don't allow them to grow, that stops them from growing marijuana, but you won't even let them grow an avocado seed in the windowsill. What I'm trying to stop is the guy that's growing a jungle at my expense. I'm not having that. Hell no. I already paid for the water for the trees and the grass and the laundry and your shower. And now I got to pay for you to grow your own vegetables? Not a chance. Sorry, little emotional there. I can talk to AGLA about creating a non-AGLA disclosure, a non-agricultural disclosure if they don't have an agriculture. GLA, non-agriculture. I have a few disclosures that I use that aren't out there. Like I'm going to give you my next disclosure that I use. And I wrote this one. It's an addendum, and it basically says that there are animals indigenous to this area that may become a nuisance or a pest or cause harm, and you should use caution because they were here way before we were. Patty, why would you do that? Why would you put an addendum in a packet that says there's animals indigenous to this area that may become a pest or a nuisance? Why would you do that? Because what the hell are you going to do when the tenant that you just rented a house to in the high desert calls you to say that their dog just was killed by a rattlesnake on your property? Or that eagle in that house that you have up in Big Bear that swooped down in the yard and picked up their little dog and carried it off? Now they're calling you and complaining to you because it happened on your property. There's animals indigenous to this area that have been here before we ever built this house. They were here first.
Patty, I know you have to go, but please bear with me. I have one more question, if you don't mind.
Sure, of course. Always here for you. What you got?
Thank you. I have an old lady that moved in about a month ago, and all of a sudden, after she told me she's all alone, she wants to bring supposedly her son. I don't know if that's truly her son or not, but the son has some kind of mental issues. Also, he has a criminal record for felony, and he was jailed because he attacked someone and all that. I put it in such a way that visitors are not allowed. She says, oh, you don't even let me see my son and this and that. So how do I handle this now?
Well,
She wants to add him into the lease. I haven't said really yes or no. How would you handle it now?
I'm going to assume that this son is not a minor.
No. It's a grown up, 20, 30 years
Hey,
old.
I'm just making sure everybody's paying attention to what we're saying and talking about, okay? If they're a minor, they're a protected class. If they're not a minor, then they're not a protected class per se, okay? Thank God they're not married. You don't have to allow it. With visitors, I do 3 consecutive days because you have to allow them to have a visitor where it's against their constitutional right. Can't tell people they can't have any visitors.
Okay, visitors mean they can just come and see and go, or they have to sleep there. I mean, visitors,
You
it doesn't mean.
If you come to my house for dinner, are you a guest?
Okay,
Yeah.
clarify, please.
You're coming to my house for dinner. Is that allowed? You're a guest for dinner. You're leaving.
So that's not a visitor then.
That's a guest. You came to my house as my guest and had dinner. I'm still responsible for anything you do on my property while you're there as my guest. But I should be allowed to have you over for dinner, yes?
Okay.
Mine says no guest can stay more than 3 consecutive nights without written consent of the landlord.
Okay, and the rest of the question, how would you handle that now?
You don't have to allow it. They're not married. He's not a minor. I'm sorry, I'm not allowing another occupant in this premises. The answer is no.
Thank you, Patty.
Keep it simple, right? If they were married, you'd have to allow it. If he was a minor, you would have to allow it. You don't have to allow it here. I'm sorry. Unfortunately, I'm not allowing another resident in this particular unit, or I'm sorry, he doesn't qualify to live here. He doesn't meet our criteria. If he was a minor, you'd have to allow it, like I said, but otherwise you're clear. Does
Thank
anybody?
you very much, Patty.
Time? Oh, I see other things. Hang on, Tony, I saw you. Val got one. I just added a laundry hookup to a unit that I pay water. How can I make them help pay for a water for a duplex in Kern? Use the RUBS system, RUBS. The RUBS system. And what you do is tell them that they'll be responsible for their own water bill. They have to be on a month to month for you to make this change. It's a 30-day notice, a change of terms of tenancy. And you're going to use the RUBS system, RUBS. You're going to take that water bill that comes in and you're going to divide it by 3. One tenant pays a third, one tenant pays a third, and you, the landlord, pay a third. Why did I make you pay a third? Why, Patty? I don't live there. No, but you're responsible to keep the water to the common area and the laundry. And it's a really good way to make them not kick, scream, and fight when they have to pay a third of the water bill, because so do you, and you don't even live there. So that's how you argue when they don't like that they have to pay a third of the water bill. Did you just want to pay half? Because I'm paying for a third of it and I don't even live there. It helps you with the argument when it comes about, because it will come about. How old is a minor? Under 18. That makes them a child. As soon as they turn 18, they're an adult. Got it? Minor children are protected in the state of California, not adult children. They're no longer a minor. Same problem, tenant in LA County, unincorporated area. I have many plants in the rear entry steps that could be considered a tripping hazard. They don't want to move them. The health department said they can't do anything about that. You're right, the health department can't. They also have some on the kitchen windowsill. What recourse or notices of change terms of addendum should I have to solve this problem? A non-agriculture disclosure addendum, where you don't allow them to grow anything on the property, not even an avocado seed in the windowsill. It's a non-agriculture disclosure. And wait until the moratorium's over and then send them a 30-day notice to change of terms. If it's not Larso, okay? Tony, I hope you got that. Does anybody have anything else? Because I'm going to end this for today. We went a half hour over. Sorry, everybody.
Patty, thank you so much. You're wonderful. Really, I mean it.
You guys are all wonderful. You don't even know. If there's anything that you guys need, let me know. Have a great week. Have a great holiday. No, I will be back before Christmas. So I will see you next Wednesday right here. Bye, everybody.